Yourselves. Greetings, everyone. I'm Martha Zavala, President of the League of Women Voters, Pasadena area. Welcome to Thursday with the League, holding police accountable for civil rights abuses. Thank you for joining us. Too frequently, we read headlines about probable or obvious police mishandling of incidents, the subsequent stonewalling by police to hide damaging information from families, the media, and the public, and the resultant citizen protests. This delay in sharing factual information breeds distrust in the police and delays or destroys the ability to hold police accountable for their actions. Should individuals who believe their civil rights have been violated decide to file police misconduct claims in the courts, the laws of the land rise up to protect the police agency and the officers, making it difficult to hold law enforcement accountable to the public. As you know, the League of Women Voters neither supports nor opposes candidates or political parties at any level of government. However, we always work on vital issues of concern to our members and the public. Our program today is consistent with the League of Women Voters positions related to good governance, including transparency and accountability. Our program today is sponsored by Policing Practices Subcommittee of Social Justice. Chris Ockershauser, chair of the subcommittee, will be introducing our guests, who are LWV California's Deputy Director for Social Policy, Ashley Ravichet, whose work on criminal justice reform is celebrated throughout the state. She will be interviewing our guest speaker, Joanna Schwartz, Professor of Law at UCLA, about her book, Shielded: How the Police Became Untouchable. I will remind everyone that the topic of police accountability is complex. Some of the solutions discussed or proposed are not specific LWV policy, but are offered for consideration. That's why we are so pleased to have Ms. Ashley Ravichet from the LWV California here today to guide our discussion. Now I will provide a brief summary of the program for this morning. Our guests, after our guests speak this morning, we will spend about 25 minutes taking questions from our attendees, that's you. Please contribute to our event by asking questions. You can enter them in the Q&A box at the bottom of your screen. Ms. Ravichet will present the questions to Professor Schwartz and answer those directed to her. Be aware that your questions may be edited for brevity and to avoid duplicates. We may not have time to include all the questions, but if we don't get to yours, please send it separately by email to events@lwv-pa.org, and we will try to get you an answer. Please do not enter your question or any comments in the chat box. This feature is used by the webinar staff to keep things running smoothly. If you have concerns about sound or anything else, you can type them in the Q&A and someone will try to help you. After the Q&A, we will offer you the opportunity to get more information on how to advance the cause of police oversight, accountability, and transparency. And please, League members, be prepared to stay tuned for a special announcement before we close the webinar. We are grateful to Pasadena Media. They are recording this event, and we will post it to our YouTube channel within a few days for viewing. Professor Schwartz, Ashley, and Chris, thank you so much for joining us today. Chris, I'll turn it over to you. Please tell us a little bit about your work and introduce our speakers.
Good morning. Before I introduce our guests again a little bit, let me explain briefly the work of our League's Policing Practices Subcommittee. We have focused recently in trying to help fully implement landmark state legislative reforms at the local level, reforms that sought to reduce the high number of Californians killed by law enforcement. The law, AB 392, targeted the use of deadly force at an officer's discretion of what was reasonable. The reform called for the use of such force only when necessary to save human life. It contained other reforms restricting what officers thought were reasonable when using force. For example, the reforms would have required officers to use de-escalation techniques when feasible prior to the use of deadly force. However, resistance to limiting discretion of officers by powerful policing interests have muddied and distorted the interpretation of new policies. It remains now for the courts to interpret the reform law. Currently, we are exploring policies and practices of League area cities on stops that are pretext for more invasive and often contentious inquiries, and of consents to search persons for even minor traffic violations that can lead to contentious wrongful searches of people and their vehicles. These police practices abuse too often violently the civil rights of those stopped without legal recourse to accountability. Professor Schwartz sees lawsuits by victims of police abuse of their civil rights as key to deterring further such abuses and to securing justice and accountability. But these lawsuits have been blocked by a legal doctrine of the Supreme Court known as qualified immunity, which prevents victims from filing lawsuits and now protects police. She shows there are other methods and avenues at the state and local level that can curb police having maximum discretion with minimum accountability when they abuse people's civil rights. She notes that traffic stops, the most frequent interaction between the public and police, and too often deadly, are overdue for greater accountability. We join Professor Schwartz in exploring ways to achieve this locally. Let's welcome now Ashley Ravichet with the State League, who will discuss these matters with our guest, Professor Joanna Schwartz, Professor of Law at UCLA and civil rights attorney prior to joining academia. She writes that what puzzled her then was why so many people with terrible experiences of police abuse of their constitutional rights were unable to sue the police for accountability and financial restitution, and unable to deter police from further abuses. She began to research the question of why this was happening when she came to UCLA. Her book, Shielded: How Police Became Untouchable, is the result of that research and answers why, as well as how we can regain legal protection from abuse of our constitutional rights. Let us begin.
Thank you so much, Chris. Thank you to the League of Women Voters of Pasadena for hosting this Thursdays with the League discussion. I'm here with Joanna Schwartz, the author of Shielded: How the Untouchable. My name is Ashley Rabichet. I am the Volunteer Deputy Area Director of Social Policy for the League of Women Voters of California, as well as the Program Director for Criminal Justice. Ms. Schwartz, you examine some of the legal protections, including qualified immunity and no-knock warrants, that have insulated law enforcement officers from their actions, which has resulted in an erosion of officer legitimacy and community trust. But before we get to your recommendations on some local reform measures that our members can advocate for to improve transparency and accountability of our agencies, let us take a few minutes to level set for those who are new to this conversation. And first, I'd like for you to briefly explain what qualified immunity is and describe how it has evolved in the courts as a legal tool to bar victims of police brutality from their ability to raise claims in civil rights violations or seek justice at all, either in direct compensation or as a deterrence to misconduct.
Absolutely. And I echo the thanks for having us here for this conversation. So qualified immunity is a phrase that has come up a lot in the news, particularly in the past couple of years. But even as it's been talked about a lot, I think it's still difficult to understand in just sort of common sense terms what this defense is and what it does. So to take a step back, when a person believes that their constitutional rights have been violated by the police or any other government officials for that matter, they can file a lawsuit under a federal statute that's referred to as Section 1983. And it's a statute that has been in place since the years after the Civil War. It was enacted in 1871. And became sort of recognized as a way to sue government officials for constitutional violations in 1961, 90 years after it was first enacted, sort of in the beginning, or as the civil rights movement in the United States was really gaining steam. And that statute, Section 1983, allows people, when their constitutional rights have been violated, to bring a lawsuit in federal court alleging a constitutional violation. In 1967, so 6 years after that right to sue was first recognized by the Supreme Court created this defense called qualified immunity. And it is not a defense that's written into the statute, into 1983. It's not written into the Constitution. The Supreme Court actually borrowed it from common law in the state of Mississippi, and described it as a good faith defense. If an officer thought they were following the law, and they were acting in good faith, that should be a protection against damages awarded against that officer. So when it was first created, it was understood as this good faith defense. But qualified immunity has shifted its shape and really expanded its power in the following years. In 1982, the Supreme Court said, actually, officers' good faith doesn't matter. The goal should be looking at whether officers violated clearly established law. So officers could act in bad faith so long as the law was not clearly established. And then the Supreme Court has made it progressively more and more difficult to find clearly established law. So today, to read the Supreme Court's opinions, In order to overcome qualified immunity, a plaintiff, even if their constitutional rights have been violated, have to additionally find a prior court case with nearly identical facts in which a court previously found that an officer violated the Constitution. And as I describe in my book, there are many examples of cases involving really egregious misconduct where officers have been shielded from liability simply because they had the good fortune not to violate someone's rights in a way that had not previously been ruled unconstitutional before. And just one example, there was a case brought called Jessup versus City of Fresno, where a Fresno police officer, during the course of a search of a person's home, stole $250,000 in rare coins and cash from that person's home, did not return it. The person sued, and the court granted the officer qualified immunity, finding that even though the officer should have known it was wrong to steal all of that money from the person they were searching, there was not a prior court case with similar enough facts to put that officer on notice that what he had done was wrong. And there are many, many examples of cases like this where there are clear constitutional violations and officers are nevertheless shielded from qualified immunity. That is part of the reason that I think this term has taken on such significance in the political debate about police reform and accountability.
Wow, that's a lot to unpack. You touch a little bit more on the limited opportunities to reform qualified immunity at the federal level in your book. And you highlighted some promising action and state reforms that have focused on some of the reform agenda of alerting municipalities of harmful practices so that corrective action for police accountability can be taken, giving innocent victims of police brutality that effective civil recourse so that they can have a more just outcome, as well as some of the other reform discussion around qualified immunity of holding police accountable just so that we can address severe misconduct and negligence that is resulting in these civil rights violations. And before we move on from kind of the legal framework of this discussion, I want to focus on a concern that many advocates have in implementing police reforms. Advocates like the League, some of our colleagues and partners. One of the major issues is that there is no right of private action. There's no right of action, or there's a limited right of action for an individual to ensure legal compliance. And that's true for all policing reforms, not just in the space of qualified immunity. So I guess taking that step back, does the U.S. Constitution actually provide individuals protection from civil rights abuses by law enforcement officers and or their employing agencies? And if not, is this a result of this case law that you just shared with us, or is this a lack of statutory authority?
Well, I think that there are a lot of barriers to relief in these cases. There are a lot of shields, as I describe in the book, that have been erected. And I think that Section 1983, this statute that allows people to sue when their constitutional rights have been violated, in theory, provides an adequate remedy. But in practice, all too often, it does not. And part of the reason is qualified immunity. But there are many other barriers to relief that I talk about in the book that also need to be considered. For example, the way in which the Supreme Court has interpreted the Fourth Amendment to the Constitution, which protects against unreasonable searches and seizures, in practice is not an adequate, I think, protection for people who are having their liberty and their lives harmed by law enforcement. And part of that, I don't know that it's the problem is with the Constitution itself. To my view, it's the way in which the Supreme Court has interpreted the protection against what the Fourth Amendment calls unreasonable searches and seizures. And if you hear that language, you might think, I certainly think, that it would assume that it means that if a person has done nothing wrong and they are stopped or searched or arrested or have force used against them, that is unreasonable. But the way in which the Supreme Court has interpreted the Fourth Amendment, it's in terms of the view of the officer. So the officer can stop someone or arrest someone, use force against someone, even kill someone who has done nothing wrong. And so long as the officer in the moment believed that what they were doing was reasonable, then the person's constitutional rights have not been violated. And I think that understanding of the Constitution's protections is a significant part of the problem. And by the way, just to remember, qualified immunity comes into play only after a person has actually shown a violation of the Fourth Amendment. So it's an additional protection on top of that. You mentioned also local government liability and responsibility. And this is another area where the way in which the Supreme Court has interpreted Section 1983 makes it very difficult to succeed. So in private business, in private disputes, if you were hit by a ABC food truck, you would not think to sue the driver of the truck. You would sue ABC Food because they employ the driver. They have the money that could pay you for your injuries. But when it comes to the Supreme Court's interpretation of local government responsibility, they have a different standard, and they say that the local government must themselves violate the Constitution by having an unlawful policy or an unlawful custom that caused the constitutional violation. And that can be as difficult to overcome as qualified immunity itself. So I don't know that the statute, that we need another statute. We just need a different interpretation of the statute that we have. And as you suggested in the beginning of your question, there are things that the Supreme Court could do, that Congress could do, but there's a lot also that state and local governments could do to make the system work better than it does.
So let's stay here for a little bit in that issue of liability. And I'm going to be asking some questions about just the narrative of this reform discussion, because there are very strong feelings on both sides. But before we unpack that a little bit, I want to just share that a study of 81 jurisdictions over a 6-year period found that in California, no law officer paid a single penny in civil rights settlements or within their judgments. So given this data, would reforms to qualified immunity either increase personal liability for police misconduct or possibly bankrupt enforcement agencies, which is a common narrative that we are hearing?
So that's my study. That's my research. When I looked at 81 law enforcement agencies across the country over a 6-year period, 99.98% of the dollars were paid by local governments and insurers, not by officers. There were 2 jurisdictions, New York City and Cleveland, where officers paid anything. And what they paid was on average $4,000. And this is, officers did not pay even when they had been disciplined, fired, sent to prison, even when punitive damages awards were entered against officers to punish them for misconduct. And those protections have nothing to do with qualified immunity. Although people say often in defense of qualified immunity that we need that protection so that officers won't be bankrupted. It's an entirely different set of protections that shield officers from bankruptcy. And those are indemnification laws. These are laws put in place across the country that provide, as a matter of statute or sometimes local policy, that when an officer is sued, he or she will be provided with a lawyer, and any settlement or judgment will be paid from local funds. California has this kind of indemnification statute. It's one of the broadest in the country. It provides that local governments are required to indemnify officers when they are acting in the course and scope of their employment, which is also interpreted broadly to really encompass anything that they do on the job, and anything, even when they do it off the job, if they do it sort of using their badge, their gun, their patrol car to reflect their authority. And in California, officers are not promised indemnification for punitive damages, but local governments can elect to also indemnify for punitive damages. These are awards that are entered by juries with the intention of punishing the officer. But when I did my research over the 6-year period, I looked at in California, officers were indemnified for every settlement, every judgment of damages. The one time when an officer was not fully indemnified, it was for a $200 punitive damages verdict against a sheriff's department officer, and the money was never collected. It wasn't worth the time for the lawyer or the client to try to collect that $200 when there had been $160,000 judgment in compensation that was awarded against the officer and paid by the city.
So beyond this conversation of becoming bankrupt if we hold our officers accountable, what are some other common narratives that you see perpetuated by opposition to reforms, whether that's reforming qualified immunity or just reforming some of the transparency and accountability measures for our officers? We're seeing this unfold a lot in local government, but also within the unions and the agencies themselves. So I'm curious, what are these narratives that you're seeing in regards to balancing those protections for civil liberties at the expense of victims, or common narratives over policing reforms at the cost of public safety? Perhaps you can address that a little bit.
Sure. I mean, the claims that are made, in addition to officers being bankrupted. I mean, in the qualified immunity space, another concern is that officers will be sued for split-second mistakes made in the heat of their jobs, which is also the way in which, as I described, the court has interpreted the Fourth Amendment already gives officers a great deal of leeway to make mistakes and still not have violated the Constitution. More generally, there are the more general notion is that officers need maximum discretion in order to fight crime, maximum discretion, maximum authority. And without that, I think that the stated or unstated threat is that officers won't be able to do their jobs, that crime will surge, and that we will all be endangered. As a practical reality, that the evidence has shown that in departments where there has been bright line rules restricting police power in various ways, there haven't been those crime streaks. In New York, for example, there was a rule in the 70s preventing officers from shooting into cars, which is a very dangerous thing to do. Over the past decades following that, there has been a dramatic decrease in deaths and not a comparative increase in crime related to that. And yet, in many cities across the country, officers can still shoot into cars. This relates also, I think, to ongoing debate and discussion about the power of officers to use low-level traffic stops and engage with people in traffic stops. Again, there's sort of a notion that officers need to do that in order to fight crime, but there have been restrictions on that power in various cities across the country, and we have not seen an increase in crime as a result.
Well, thank you for that. In your book, you also note that local and state governments have proved to be promising creative labs of reform, suggesting that law enforcement agencies could better learn from analyzing trends in lawsuits as an approach to doing that feedback loop and changing procedures and policies internally. Can you explain a little bit more about this feedback loop and how enforcement agencies can learn from past misconduct to usher in changes to their procedures?
Sure, and I mean it's important to sort of start with the first insight, which I learned during my research that informs this book, that most police departments do not gather and analyze information from lawsuits brought against them. Again, you would think that if you were sued or if you owned a business and your employees were sued, you would want to take a careful look at those cases and try to figure out what happened, and how to prevent something similar from happening in the future. But surprisingly, that's not what happens in most police departments. Instead, there are sort of two different arms of local government. The police department on the one hand, and then the local city attorney's office on the other hand. And in many places, when a lawsuit against a police officer is filed, the officer will learn that they've been served with the case, but the city attorney's office ends up defending the case, gathering the information related to the case, and then any settlement or judgment is paid from the central funds, not from the police department's budget. And the information from that lawsuit doesn't get filtered back to the police department. So they may know little or nothing about the specifics of the individual cases that have been filed against them. I have found some places that do gather and analyze this information and have learned important things about the claims against them, have seen trends in particular officers, in particular station houses, particular types of behavior that they've then investigated further, and been able to address the underlying concerns. And part of what I argue in Shielded in the last chapter of the book is that local governments should be requiring their police departments to pay closer attention to these suits. Cities and counties across the country spend a quarter to a third or even more of their budget on the police department, and that is allocated to the department. And one thing that a local government could require in return is that that department pay attention to the lawsuits filed against them, to the information in those suits, and try to identify patterns or concerns that are raised from those cases that they can use to prevent something similar from happening in the future.
Thank you. I have so many questions that are swirling through my mind now, but I'm going to try to just get through what I have listed out, and then maybe we have time to continue in some other deeper dives in this area. So before we move on from this particular topic, I want to share another report that was just issued by ProPublica in 2021. It looked specifically at New York Police Department and noted that a small fraction, roughly about 800 out of their tens and thousands of uniformed officers, were named repeatedly in multiple lawsuits, according for millions of dollars in settlements. Here too in California, we had the Little Hoover Commission hearings, which also shed a light on this practice where the pattern of misconduct can be traced down to a handful of individuals, where excessive force, once they use it, they're more likely to respond in the same way in the future and continue to use force. And if it's excessive, they continue to use excessive force as their response. So in your opinion, is this a result of training, policy, or a lack of accountability? And you can choose more than one.
I was going to say, I mean, I think that all three are probably a part of the concern. Certainly, policies that don't create bright line rules about what police can and cannot do, which is true of most police policies, and it's true of the Supreme Court's decisions. Really create a world in which officers can abuse their authority. And then the lack of accountability couldn't be more important. The concern when you see an officer who has violated people's rights or used excessive force on one occasion, that's one thing. But if they're repeatedly allowed to abuse their authority and without consequences, then that is even more cause for concern. And I think part of it relates to lawsuits. In one of the chapters of Shielded, I focus on the New York Police Department and the lack of information that officers and the department has about these prior suits. And I talk about the fact that there was one of those officers had been sued dozens of times. But then when he was asked about these cases, he said, I don't know anything about them. When they go to court, I don't follow it. And so, and the supervisors and heads of the department don't follow it either. And this is a huge problem. If there is all of these dollars being paid, all of this misconduct occurring, but there are no consequences of these civil cases, that is a big problem. It also happens, though, there is another way to get some form of accountability through internal police department supervision and discipline and termination. But part of the reason that I rely so much on lawsuits as a form of accountability is that those internal affairs investigations are really flawed as well. Often there are union agreements that make it difficult to thoroughly investigate these cases. And even when there's a finding of wrongdoing, arbitration agreements or appeals protections built into law enforcement officers' bills of rights mean that those findings, even as they're rare, often get overturned. So to my mind, there are things that could be done on the front end through better policies to prevent these kinds of repeat offenders. But a key part of it is also the back end accountability after the wrongdoing has occurred. And these kinds of examples just make clear how ineffective our current system is and how all of these protections aimed at giving officers maximum authority and discretion are really not serving our communities well.
Well, let's switch gears here for a brief moment and focus on some of these obstacles that are appearing at the local level. You speak of the agency being a barrier to that feedback and that deeper understanding of what is occurring. But at the local level, we also see actions that often hinder accountability. So can you explain a little bit how city councils and police unions often curb accountability? You touched a little bit about those MOUs and arbitration agreements, but I'm curious if this city council action or the local government is resulting in either the financial instability and they're afraid of holding individuals accountable and taking up that liability of acknowledging liability, but then also just kind of speak about ways that we can maybe circumvent some of these concerns and bring these stakeholders to the table to help change some of these practices.
Well, I do think city councils are a huge, should be a huge focus of advocacy, and there are a lot of things that can be done. As I mentioned a moment ago, it is the city council or the county council that ends up setting budgets for these law enforcement agencies and for the rest of our agencies. And it's the city council or county council that ends up negotiating the union agreements in these cases. And so they do have a tremendous amount of power over or role to play in negotiating the accountability of local law enforcement agencies. City councils across the country have hired in New York City, for example, the city council hired an inspector general for the police department that has overseen the collection and assessment of information from lawsuits and has moved the NYPD forward in becoming more attentive to these suits. An inspector general or other kind of outside civilian reviewer that can be put in place by a city council can assess internal affairs investigations and how they work. And then, of course, city councils do set the budget. They can determine how much the police department receives, but beyond that, can assess where within the city's budget the money to pay for attorneys and settlements and judgments in these cases come from. In most cities and counties across the country, payments in police misconduct lawsuits have no financial effect at all on the police department. And what ends up happening, though, is that the money to pay when there's more than expected that comes not from the police department's budget, but from other parts of the city's budget, including money that was earmarked to help the most vulnerable. So city councils have power in deciding where the money to satisfy these settlements and judgments come from, the power to renegotiate union agreements, the power to additionally to require local governments or police departments to gather and analyze and pay closer attention to the information in these suits. So there's really a tremendous amount of power that city councils have to try to advance these kinds of reforms.
Thank you for that. League members, we do the building bridges between the policy makers, the city council members, doing the advocacy of bringing our communities together. So this is a helpful place to kind of jump off from. And I will be asking a follow-up question, but before I do, I want to kind of set out that worst case example of wrongful death. And we are seeing this, your book addresses briefly about no-knock warrants. And what we have seen is that wrongful death scenarios where law enforcement agencies are not being held accountable for either a no-knock warrant that results in a wrongful death. And there are continuing loopholes in California statutes that restrict an ability of a family member to seek justice. And currently, my understanding is that the only redress is for the surviving family members is funeral costs in most of these cases. So how would reforming qualified immunity laws, in our case, it's the Tom Bain Act, help change this outcome for addressing police accountability in the most extreme situation in a wrongful death scenario?
Well, so there is still the federal law, Section 1983, that can be used in these cases. But then there is qualified immunity, which protects against that. In California, there is the Bain Act, which does allow a type of, or a limited sort of category of constitutional claims. State constitutional claims can be brought under state law, but they have their own restrictions, as you're describing. And there have been efforts in the California state legislature to expand the Bain Act, which thus far have been unsuccessful. I think that when it comes to no-knock warrants, there is a wide consensus that they are dangerous, and I think that they do more harm than good. And I tell a story in the book of someone who heard pounding on their door at 1:30 in the morning with no announcement that it was the sheriff's department, and he came to the door to answer the door with the gun that he legally possessed in his hand by his side. And then the officers opened the door, or when he opened the door, the officers started shooting because he had a gun and he was seen as a risk. But this entire event would not have, and this tragedy of this person's loss of life would not have happened if there had been a knock at the door announcing, not only a knock at the door, but an announcement that the person was a law enforcement officer. And the court in that case found that there was no constitutional violation because the officer was feared for his safety, and there was really no obligation to announce beforehand, which is a problem connected to the Fourth Amendment. But qualified immunity adds this extra challenge so that even if you were able to show that there was a constitutional obligation to knock and announce, that there would be no liability unless they could find a prior court case that had a similar finding. So I think that getting rid of qualified immunity would make that one step easier. But I think that we actually need to go even further to have a ban on no-knock warrants, and a requirement of knocking and announcing, with the possible exception for the most extraordinary circumstances. But right now, the way that the federal Constitution is understood, the requirement of a knock and announce before a search is almost never required by the law.
Interesting. Well, I know, speaking from the league, we would like to see more states take up that issue. I know the no-knock warrants have been banned in Florida, Virginia, Oregon, and here in California, we do have a knock and announce. As you mentioned, there's always exceptions of when law enforcement can get a no-knock warrant and the knock and announce, and how they can continue to utilize the older procedures where we know is a risk to bystanders, it's a risk to individuals. And we've seen just harmful cases of wrongful death in the news over the last few years of when this turns into a negative outcome, when they arrive at the wrong house, when they arrive and an individual is a legal gun registered to their name and is not understanding why someone's pounding on their door in the middle of the morning. As far as specific exceptions, do you believe that is sufficient in the practice, or do you think that it would be better to take an abolitionist stance at the federal level of a no-knock warrant?
Well, I suppose I think that getting rid of no-knock warrants, I think, is where I come down and what I prefer in my sense, given the data about what is required. I also think that bright lines are easier to follow than lines that are dotted with various exceptions. I also think that when we have a rule like a rule prohibiting no-knock warrants, there is again the question of enforcement and accountability. So if there's a rule and someone violates it, what are the consequences of that? If it is not written into the Constitution, it is not it's sort of questionable what the consequences would be in those cases. And I think that needs to be addressed as well. And I certainly think at a minimum that a person should be able to recover for their injuries as a result. In these conversations, I think it's critically important to remember that we are talking about people losing their lives, getting harmed, and in ways that can affect them for the rest of their lives. And I think the question that we really should be asking is, when something like that happens, when an innocent person who has done nothing wrong loses their life or is shot or is arrested, what do we as a society think that person deserves? What do we believe that is important for them to receive? And we know that the money in these cases is not coming from the officers themselves. It's coming from the communities that provide these officers with their badges and their authority and their weapons. And in my view, in a case where someone who has done nothing wrong has had their door broken down and been shot at or arrested, that they deserve some compensation to make themselves whole. And that is really where I think our system needs to function better than it does.
Thank you, Ms. Schwartz. It's now time to open up our discussion to some league member questions. But before I do, I want to provide you with an opportunity to just offer some closing remarks. You've shared a lot of information with us today. We've done some deep dives on some really complex legal issues that concern law enforcement and holding them accountable. So do you have any closing remarks to summarize, or perhaps I could plant something in your mind? Perhaps you could give us some advice for league members who want to focus on the local action and what they can do to achieve and increase accountability and transparency at their law enforcement agencies.
Yeah. So first of all, I think that the first piece of advice you've already started doing now, which is to educate yourself about these barriers. And they are very complex. They are, I think that they are hard to understand and grasp. And that's, frankly, part of the reason that I wrote Shielded, which is an aim for people who aren't lawyers, who don't want to read law review articles, to get a full understanding of what these barriers are to relief, how they function, how they interact, and how they affect real people whose lives have been turned upside down by police violence and then are trying to seek justice in the courts. So getting that understanding, I think, is hugely important. I also think that focusing locally is very important. Right now, I think a lot of the barriers to relief in these cases have been created by the Supreme Court, and Congress hasn't done anything much to help lessen those barriers. The Supreme Court doesn't seem interested in lessening those barriers. And so we really are left with state and local government change, and so state and local advocacy to try to make these systems work better than they do now. And I think that for your members, advocacy at the local level and the state level is crucially important. And we've talked a bunch about things that city councils can do differently. State legislatures also can play a very important role. In California, has had more success than many states in passing police reform bills, but there's more certainly that can be done. And when I talk about in the last chapter of my book, there was an effort to create a state law cause of action in California that did not have qualified immunity as a defense, expanding the Bain Act. And these same concerns about officers being bankrupted essentially led to the defeat of the bill, despite the fact that officers never contribute anything to settlements and judgments entered against them as a matter of state law in California. So this is a place where myths that are really unfounded and have no basis in reality are guiding the debates. So for those of you interested in making a change, educating yourselves about these protections, advocating at the state and local level for common sense reforms that would lessen the frequency with which officers are engaging with people, and also creating better systems of accountability on the back end is hugely important. And I think California could be a leader in this space and help create a better state framework that then can be used by jurisdictions around the country.
Thank you for that. And I know you touched on some of the state level reforms we're doing in California to amend or expand access to the Tom Bain act. I know with Senator Bradford's bill dealing with officer decertification, that was one of the most recent attempts to broaden and to dampen qualified immunity in severe misconduct as we have reformed under this state. And Colorado has also placed a restriction on utilizing qualified immunity as a defense, but specific to use of force instead of the whole gauntlet of possible misconduct that, at least in our state, we deem worthy of a second look and a possibility of decertifying an officer for their actions, such as perjury, unlawful arrests, you know, placing evidence in a location that it shouldn't be there. There's a lot of misconduct potential that we are looking to address in these reforms. You mentioned a little bit about these narratives and the myths, and there was a question from the audience about unions and what role unions or their association or organizations such as PORAC play in supporting either reform or opposing reform, both at the state and often the local level. Could you perhaps speak to that role of the associations and the unions and perhaps give us some guidance on your recommended approach?
So unions have played a big role in recent efforts to oppose police reforms. And they have relied heavily on the narratives about officers being bankrupted and also about the need for officers to have maximum discretion in order to do their jobs. And I should say, decades ago, unions were using these same kinds of arguments to first create the kinds of law enforcement officers' bills of rights that have grown so powerful and have given unions so much power. They've now, in more recent years, utilized these same arguments in state legislative hearings about qualified immunity and in opposition to the potential federal reforms to qualified immunity that failed in Congress. And I've been on many of those in state legislative hearings where I am offering the kinds of research that I have done over the past decade and a half about officer indemnification and all of the reasons that these myths of officers being bankrupted for good faith mistakes really hold no basis in reality. And the union officials do not cite to any research supporting their claims, but simply assert that their officers are going to be bankrupted for good faith mistakes, and we need to show more support of our officers for them to be doing their jobs. And again and again, those union arguments, which are heavy, to my view, on fear and passion, but very light on facts, end up winning the day. And I think that there are law enforcement officers out there who support qualified immunity reform. There are very good arguments why law enforcement should want to have a functioning system of accountability. Bad officers make good officers' jobs harder. Bad officers make community trust more difficult to achieve. And if you survey officers, they do want a sense of accountability for officers who engage in misconduct. So if the question is how do we combat the union rhetoric? I mean, I think one answer is continuing to be educated and being able to respond to the kinds of concerns that they've been raising, and I hope that my book can be helpful in those efforts. And I think another key part is finding law enforcement officers in your communities who are also educated about these truths and who are willing to stand up, and articulate the truth of the need for systems of accountability.
I just have to take a breath here because this is one of those conversations that it is difficult to navigate. Um, I, we do have some information that we will be sharing after this discussion. And so I just also want to take the opportunity to thank you so much. We have room for one or two more questions. The first question that I would ask is, you touched on in several different examples the issue of civilian complaints and civilian oversight or an inspector general. So I'm curious if we could sit in that space for a little bit and if you could explain either the impact that you are seeing in your research of civilian complaint system and or civilian oversight system and what role that plays in resulting policy changes that improve and or reduce misconduct in an agency such as law enforcement.
Well, I do think that the power of civilian oversight, really, the devil is in the details with those kinds of efforts. It really, there are certainly some civilian overseers who have very, very limited authority in terms of what they do, and then others, far more. And so I suppose as a first point, it's important to make clear that civilian oversight needs to have meaningful powers, both to understand what's happening within the department and to request or require changes that are key to any kind of civilian oversight's success. I mentioned before the New York City Police Department's Office of the Inspector General, which I think has been a good model where the department or the department is required really by the city council to respond to the Inspector General's assessment, and the city council gave the Office of the Inspector General the power to review lawsuits and other kinds of civilian complaints and make recommendations about how the department should respond to these kinds of complaints and lawsuits. And there have been, and over the years that this has been in place, important changes in terms of the reduction of lawsuits being filed, which is a cost benefit to these local communities, as well as understanding better what is happening that is getting officers into trouble and steps made to try to address those concerns. But again, I'll say that all of this depends on who is in power and what kinds of commitment there is to meaningful oversight. And when the city council is not engaged or the mayor's office is not engaged in this kind of oversight, it can be very difficult to make those kinds of changes.
Well, we have our work cut out for us, certainly. We have another question that just popped into the chat. It says, other than money, what other ways might officers feel the impact of their misbehavior that would help them change their behavior?
Terrific question. So one obvious impact would be if there was an impact on the job in terms of their promotion or their assignments or their supervision when there is misbehavior. And some of those challenges to those kinds of consequences are created by union agreements and limitations on what can be investigated and when, for example. But if you think about lawsuits, in many places, what happens in a lawsuit is viewed as completely irrelevant to how the officer is supervised and trained and disciplined. There would be, though, the ability. There's not a restriction on the ability for police departments to look at these cases, to look at the officer's deposition testimony, to look at the evidence that came out during the course of litigation and draw lessons from that and talk with the officer about that. And there could be meaningful consequences having nothing to do with money that are based on the revelations that come out during these cases. And I actually think that that would be potentially a more powerful and more relevant consequence in these cases. There's another question in the chat that maybe the same questioner had related to trouble recruiting officers, and I think this is and questioning how does this factor into what we're talking about here. I think it's incredibly important, and frankly, some of the most recent challenges to officer accountability efforts have been defeated based on this concern about the need to recruit officers, and that we shouldn't have rollback qualified immunity, for example, because we're having so much trouble recruiting officers. I would say that challenges recruiting officers is a problem that researchers have tied more to our economy, to the number of jobs that are available in other sectors, and to the relatively low pay that officers are getting in these positions. Is I think maybe more of an issue, or maybe an important issue, that makes it difficult to recruit officers. But another reason that I think it's difficult to recruit officers is that being a police officer these days, is potentially signing up for a great deal of community criticism, public criticism. And to my view, the answer to that is not to give officers blanket authority to do whatever they want to do, but instead to improve relationships between community members and police officers, to improve the legitimacy of law enforcement as a profession. And part of that, to my view, has to be having meaningful and effective accountability for officers. So I think that we're kind of going about this the wrong way or state legislatures that say we can't have any police reforms because then it will be difficult to recruit officers is looking at things backwards. I think we need to have restore trust in policing in order to improve recruitment. And that is going to require having meaningful accountability and a sense that officers are not above the law.
Now we have time for one more question. This is coming from Valerie. She says that knowing that this is out of context, it sounds like we should be making our concerns, complaints as a community, not only to the oversight commissions or bodies, but also to the mayor and any other pertinent stakeholder. Would you like to respond to that?
I absolutely agree. And I think that we've seen that communities can make a difference, and engaging with your community can really matter. And I think that it's important to have those conversations, to have that engagement outside of these moments periodically where there's a viral video of a police shooting or killing that brings people's attention to an issue for a day or a week or a month. These conversations need to last far beyond those moments where there is a viral video, to be thinking about what we want our communities to look like, how we want our systems of accountability to function, how we want law enforcement, what role we want them to play in our communities. And I think those are questions not just for the overseers, but for the city councils and the mayors that are responsible for the union agreements, who are responsible for setting the budgets. And these kinds of issues around budgets and risk management, may not be the sexiest topics, but they're actually quite important. And because they're not as much hot button issues, perhaps there's a way in which we could get to some agreement on these issues more quickly than we could on an issue like qualified immunity that has gotten so much political attention over the past couple of years.
Well, I want to thank you for your time. I'm going to switch gears and bring it back to the League of Women Voters of Pasadena to share some updates, and switching gears from our education through our advocacy. And then perhaps if there's an additional question, we still have a few more moments when that presentation continues. I've really appreciated this conversation. Thank you for sharing your space and your energy and your passion for this topic. It is very clear that you've dedicated some significant research to this book. I want to impress every single league member that has the opportunity to check it out, to go purchase it. Go ahead and hold it up. So, Shielded: How the Police Became Untouchable. It is a fabulous read with a lot of really good recommendations as well as research. Thank you so much, Joanna. I appreciate you.
Well, thank you so much. Thanks for having me here.
So, Chris, if you would like to go ahead and share a little bit more about the League of Women Voters California,
Sure.
Supporting advocacy on SB 50 and AB 93. I would just like to quickly mention that the League of Women Voters advocacy is done through our position on criminal justice, and we support a criminal justice system that is just, effective, equitable, transparent, and that fosters public trust at all stages, including policing practices, pretrial procedures, sentencing, incarceration, and reentry, and that we focus on practices that promote safety for both officers and the communities that they serve. Thank you so much for your time.
By the way, this is the book you were referencing. Go get it. Yes, thank both of you, Professor Schwartz and Ashley, for a really exciting discussion of what's possible and hopeful, and some of which I hope we'll be doing. But I do want to talk about some legislation that we're active on. This is the state league's some of their priority bills. Support for Senate Bill 50, Senator Bradford of Gardena's bill to prohibit a police officer from initiating a traffic stop for a low-level violation, a pretext for further invasive action unless there's a separate independent reason. And we also support Assembly Bill 93 that would prohibit police officers from asking for consent to search a person or their vehicle without an evidence-based legal justification. These bills will help limit unjustifiable police interactions that lead to more intrusive stops of people of color and often escalate to unsafe encounters for everyone involved. Wanted to mention that the State Department of Justice's Advisory Board on Racial and Identity Profiling, in its 2023 report on the surveys of major law enforcement departments, have found that people who were perceived as Black were stopped and researched and searched at more than 2 times the rate of people perceived as white. Black adolescents 15 to 17 were searched at nearly 6 times the rate of those perceived as white youth. Our policing practices subcommittee is currently exploring policies and practices of several league area cities on pretextual traffic stops and invasive consensual stops and searches for possible education and advocacy on reforms. Professor Schwartz's research and recommendations for reforms at the municipal and state levels offer many opportunities for local residents to call for these. And we should also remember that the State Department's Advisory Board of Racial and Identity Profiling survey of all state law enforcement patrol officers on their perceptions of who they stop, why, and the outcomes is nearly complete. Our league cities survey results won't be known for approximately another 2 years, it looks like. But larger law enforcement departments, such as the California Highway Patrol, sheriff's departments, and major cities, police departments. Earlier survey results show racial profiling, with Black and Hispanic motorists and pedestrians most heavily impacted. Our cities need to be prepared for likely similar results and reforms. And if we can have the slide now. We'd like to let you know that there is some additional reading that you might want to do, further articles and interviews with Professor Schwartz, in addition to her book. And we should also mention the Pacific Policy Institute of California's articles on law enforcement research and reforms. I don't see the slide, and there is a QR code also that has this information. Is it possible to put it up? Well, we will have a recording. There is a recording of today's program, and it should be available, I believe, in a matter of days on YouTube. And we want to thank you all who attended and all who participated. Thank you so much.
Thank you. Thank you, Chris, for raising the issue of police accountability and helping to pursue solutions. Professor Schwartz and Ms. Ravichet, thank you for the work that you do in this space. Professor Schwartz, you have identified another area where Supreme Court decisions have put our constitutional rights in jeopardy through some highly questionable court decisions. Thank you both for explaining the concept of qualified immunity and how it's used to shield police departments and individual officers from being held accountable in the courts. The issue of no-knock warrants really needs to be addressed because it creates highly dangerous situations. This should be an area of mutual concern for residents and officers. So we hope to hear more about your work and how we can help. And to our attendees, if we didn't get to your questions, please resubmit them via email to events@lwv-pa.org. We will get the answers to you. And please email if you would like to join Chris in addressing issues relating to police practices. She will welcome your participation. Remember, the video of this presentation will be available on the LWV-PA YouTube channel in a few days, courtesy of Pasadena Media. Members, please register for our annual meeting as soon as possible. It will be held on Saturday morning, June 10th, at the Monrovia Community Center. We will be introducing 2 new and exciting initiatives related to civic engagement and community outreach. Be prepared to celebrate Juneteenth early, so wear your colors. Thank you to our events and communications committees for working behind the scenes to host the event. And thank you to Ashley for that informative introduction of our speaker and for being our moderator during the Q&A session. And finally, to our events committee, Zoom hosts, especially Catherine, Hester, Tony, and Valerie. We close in memory of those killed through gun violence and by the inaction of legislators. We stand in solidarity with the families demanding legislative action. Thank you to all who joined us today. Remember that taking action can result in change. We need to move beyond thoughts and prayers. Thank you. Have a wonderful May.